Welcome to Family Law Talk, presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a family law firm in the St. Louis metro area, with offices in Missouri and Illinois. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. My name is Kirk Stange, and I am one of the managing partners of Stange Law Firm. Welcome today to today's topic on Family Law Talk with Stange Law Firm. It's an interesting one with the prevalence of social media out there, which is, the title is Dangers of Social Media Postings in Family Law Matters. It's a really interesting topic. We'll get to it here in just a second, but before I do, I will state, as I always do, that the choice of a lawyer is an important decision that should not be based solely upon advertisements, that the information you obtain today in this episode is general in nature and it may not apply to specific factual or legal circumstance. Therefore, if you require legal advice, you should definitely consult and hire an attorney who's licensed and competent to practice law in your specific jurisdiction. All right, well, on to the topic. Again, the topic is dangers of social media postings in family law matters, and this is based on an article that we have on our webpage, StangeLawFirm.com. If you click on the article tab, the title of the article is Steve Nash Case Shows How the Use of Twitter in a Custody Case Can Become Important. So that's the title of the article. So as a follow-up to the episode today, you can certainly go to www.stangelawfirm.com, click the articles tab, and then read the article itself. It's definitely an interesting article, and at the bottom of the article we actually cite the legal opinion itself, this is based on a case that came out of Arizona, from the Arizona Court of Appeals. The case is Nash versus Nash. In the site, for those of you that have Westlaw or Fastcase, or have the ability to pull up cases, maybe Lois Law, there's other programs out there, but the citation is 307 Pacific 3rd 40. It's a case that came out July 23rd, 2013. It's a really interesting case. I think it's important to talk about because there's so many folks on social media, Facebook, Twitter, LinkedIn, and numerous other sites out there. But, a lot of parties are tempted to sort of unleash on social media. So if they're upset with their ex, or they're upset with their current spouse, maybe, who they're going through a family law matter with, the temptation is to post on the social media sites. And maybe people just do it not really thinking. Maybe they're kind of looking for some sympathy or support of other people that are out there. Maybe they just do it out of frustration, and it's just a way to sort of let that frustration out. But the Steve Nash case really shows the dangers of doing that, especially in a custody case where kids are involved. And for those of you that aren't basketball fans, Steve Nash is an NBA basketball player, a very good basketball player who's a high-profile player, and most people know who he is, and his divorce has certainly got a lot of attention. But the basic facts of this case are this: the parties get divorced, and they enter a kind of a general non-disparagement clause in that divorce decree itself, which is really pretty typical. And we see these in Missouri and in Illinois, which is, the parties aren't going to say bad things to the kids about the other parent, and they're not going to put the kids in the middle on adult-related issues, and, they won't try to communicate through the kids between each other. And all this obviously makes a ton of sense, is what anybody going through a divorce should do, is keep the kids out of it, and that way the kids are affected as little as possible by the divorce or the custody proceedings. But in this specific case, the parties entered a joint custody agreement, and according to the Court of Appeals decision, which I have right in front of me, it stated this: it stated all communications between the parents shall be respectful. The parents agree that neither parent shall disparage the other party to the children, and that each parent shall model respect for the other parent in their interactions with the children. Neither parent shall do or say anything to the children that would negatively impact the child's opinion or respect for the other parent. So that's the kind of non-disparagement clause, if you will, that is put in the parenting agreement, which is common in a custody case. The problem in this specific case is the day the decree was issued, mother, according to the opinion, used her Twitter account to tweet a, quote, biting criticism of father's integrity. And the specifics of it, the Court of Appeals didn't even put the specifics of it in there, because apparently, I think you can presume, it wasn't kind. It was a biting criticism, and so the Court of Appeals in this case apparently chose not to republish this tweet, probably out of respect for the children here in this case, so they wouldn't read it in the opinion someday when they were adults. But that's basically it. They agreed not to make comments that were disparaging to the children about the other parent, but then the day the divorce decree is issued, mother uses that Twitter account to tweet a biting criticism, and that's what in part set off more litigation between the parties in this case. And what the trial court did with this was ultimately entered an order prohibiting disparaging remarks on social media. So they took this non-disparagement clause and they entered an order that in fact made it a little bit more specific, a little tighter, in that they prohibited either party from saying anything further on social media. And again, they relied on the clause in the judgment itself, which is this non-disparagement clause that I just read a minute ago. And in essence, Mom challenged this. Mom took this up, indicated that she thought that this violated her First Amendment rights and that she had the right to state, what she wanted to state on social media, and she shouldn't be prohibited from doing so. Of course, Mr. Nash argued, there's this non-disparagement clause, and by posting these comments on Twitter, in fact, she violated the non-disparagement clause and shouldn't be allowed to do that anymore. And so this case goes up on appeal, and the Arizona Court of Appeals ultimately found that in this case, Alejandra Nash, who is the ex-wife of Steve Nash, couldn't post these items on social media sites any longer, and the rationale based on the Court of Appeals decision was, again, one, the content of the joint agreement. So they indicated that the joint agreement itself prohibited the parties from disparaging each other to the children, and by doing this on social media, the day the decree is entered, she's trying to walk a line where she's not violating that clause, but it's very, very close, and certainly the comments were disparaging. And then they get to the fact that the kid, in this case, the kids could easily hear of these comments posted by Mom, and you might ask why. Well, in this case, Mr. Nash is a high-profile NBA player, and so presumably other people out there in the community could read these tweets and then communicate them back to the kids. In other words, kids at school, theoretically, or other parties out there could tell the Nash children, hey, this is what your mom posted on Twitter about your dad. And so, while Mom, in this case, Mrs. Nash, didn't make these comments directly to the kids, which is what she argued was prohibited by posting these on the Twitter account, it's very conceivable that these comments could then be relayed back to the kids, just given the celebrity status of Mr. Nash. And so that was kind of the basis for the opinion. The other thing that the opinion talked about, again, the high-profileness of the parties. This isn't a typical case. We're talking about an NBA basketball player who's been out there for a long time, who's widely known in the community, and so the court looked at that. And then I think if you read the opinion, again, we don't know what the content of the tweets were exactly, but they used the term biting criticism. So perhaps the contents of the tweets themselves were so bad that it caused such a concern by the court in this particular case as well. And so I don't know, would the result have been different if the tweets weren't so biting, if they weren't so harsh? Perhaps. And I think that's one thing you could kind of look at here between in looking at the facts of this case. But so if you look at the Nash case and you kind of apply it, past that, ultimately, parents have to be very careful about what they post on social media sites about their ex, or if they're still married and going through a divorce, because these postings ultimately could come back to the kids, and the kids could hear of them, and of course that could be damaging to the kids, and of course the court could find out that you're doing it and not like it, and ultimately that could result in an adverse custody judgment. And so, really moving forward, for most folks out there, it's better to keep the tweets and the postings on Facebook about your ex or about the divorce itself. It's better not to put them up at all. You put that stuff out there, and as you see in this case, it sets off a string of litigation, probably costs these parties a lot of money, this case going up on appeal. And then ultimately, you have to assume on some level the kids probably found out about this, just given the publicity of it. You can Google this case and find all kinds of articles and stories about it. And so, you post this stuff on the social networking sites, and you do it out of frustration. Maybe you do it to maybe get some sympathy or some support. But at the end of the day, it ends up affecting the kids, and that's definitely not a good thing. And so, to the folks out there, you might be frustrated with the acts, you might be frustrated by the process, but it's never a wise thing to post these in the public sphere, and certainly not on social media sites. Certainly not helpful, and not a good way to curry favor with the court, and certainly not good for the kids either, because these tweets easily can come back to the kids, and obviously younger and younger children are setting up their own social networking profiles and are able to view a lot of these just themselves by going online. So that's the case. It's a really interesting case. It's garnered a lot of attention out there. Again, if you want to follow up and get more information on this particular episode, go to StangeLawFirm.com, click the Articles tab, find the article titled Steve Nash Case, shows how the use of Twitter in a custody case can become important. So you can check that out. And if you got the ability to access case law itself, again, the citation of this case is 307 Pacific 3rd 40, and it's an Arizona Court of Appeals case, Division 1, Department C, and the date of the decision itself was July 23rd, 2013. So really interesting case. Hope all of the listeners out there found this episode interesting, and we'll see you next time on Family Law Talk with Stange Law Firm. Thank you very much.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic, or to put Stange Law Firm to work for your family today.
With Lucky Land Slots, you can get lucky just about anywhere.
Dearly beloved, we are gathered here today to... Has anyone seen the bride and groom?
Sorry, we're here. We were getting lucky in the limo and we lost track of time.
No, Lucky Land Casino, with cash prizes that add up quicker than a guest registry.
In that case, I pronounce you lucky.
Play for free at LuckyLandSlots.com. Daily bonuses are waiting. No purchase necessary. Void where prohibited by law. 18+. Terms and conditions apply. See website for details.